Well, good afternoon, everybody. It's a great pleasure to see so many of you here today to meet George Newhouse. We're very privileged indeed to have such a fine litigation lawyer with so much experience coming in to talk to us about his recent case with the Australian High Court, the CPCF case, or the one that I always know or describe to myself as the 157 Tamil asylum seeker case. May I, before I begin, acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation. It's always a great pleasure for me to recognise those traditional owners in this rather fantastic building that we have in which to do our work here at the Australian Human Rights Commission. Now, before I introduce George, I might just make a point that he's made himself in a recent op-ed that was published, and that is that commentators often look at court cases like a football game with winners and losers, but this decision, the CPCF case, is much more nuanced than it appears on the surface. And that really is the point of today's rights talk, just to get a clearer view of exactly what did emerge from this case, because the lawyers amongst you will know very well that when you actually sit down to read a decision, there's much more behind what the court is actually saying than simply a numerical counting up of how the final result emerged. But I thought that I might give just a little bit of context to what it is that George is going to be talking about. And I really would like to begin, as I have done a number of times so far this year, and that is that you'll know that this year is the 800th anniversary of the Magna Carta. And buried in the middle of that Magna Carta that King John was really forced to sign by his rebellious barons in 1215, is the provision that no free man is to be taken or imprisoned or disseised of his liberties save by the lawful judgment of his peers or by the law of the land. And that is an ancient core principle that underlies pretty well every legal system, but one, of course, that we're very familiar with. Well, some time ago, before the case that George is about to discuss, the High Court considered the fundamental right not to be detained arbitrarily in a case described as Plaintiff S4 against the Minister for Immigration and Border Protection. And the story was pretty typical. The plaintiff had arrived by boat in Christmas Island. He was stateless and had no visa. He was detained for more than 2 years under the Migration Act, and as an unlawful non-citizen was barred from making an application for a protection visa. He appeared then to be stuck in detention indefinitely. And in a unanimous judgment of the High Court of Australia that's been surprisingly little discussed, a rare unanimous decision of the court said that the Migration Act does not authorise the detention of an asylum seeker at the unconstrained discretion of the government. Rather, an alien, whether in Australia lawfully or not, is not an outlaw and cannot be detained other than in accordance with the law. What the court did, and I won't go through the analysis, but it's certainly important to read, was that the minister had an obligation under the Act to either deport him, which he wasn't going to do because he was a refugee, or make a decision to grant him a visa. But critically, that decision as to whether or not he could be allowed to apply for a visa, said the court, must be carried into effect as soon as is reasonably practical. In other words, there's some kind of a time limit to the amount of time for which a person can be detained, and that decision will depend on what the court of the day happens to think is a reasonable time or a practicable time. But one of the aspects of the decision that was particularly encouraging was that the court said that if the minister does not make the decision within a reasonable period of time, then the court will be quite prepared to use the writs of mandamus, the constitutional writs, to require that a decision is made. Now, that decision got very, very little publicity, but it's actually one which moves the law in a very interesting direction, that there cannot be arbitrary detention at the discretion of the minister, but that the minister may act only within the terms of the legislation, in this case, the Migration Act, and a decision must be made within as soon as is practicable. Now, the next case, and the one that George is going to talk about, the 157 Tamil asylum seeker case is a case where at least one of those issues was to determine what would be a reasonable or a safe period of time in which to hold those Tamil asylum seekers. Well, I can't think of a better person in Australia to be discussing this issue with us than an extraordinary litigation lawyer that George has proved to be. He did his law degree in New South Wales, and he practiced as a banking, finance, corporate lawyer in the executive world with JP Morgan's New York office. He worked in the capital markets for Clifford Chance, and then returned to Sydney, where he became an accredited mediator. He is currently corporate counsel for Surrey Partners Lawyers, where he specialises in defamation, negligence, property, finance and planning law. But he's also special counsel at Shine Lawyers, where he heads up their social justice practice. He's also the editor of the Laws of Australia, Aborigines and Torres Strait Islanders Civil Justice Issues. George was also invited in 2008. You'll remember those heady days of Kevin Rudd's summits. He was invited to be part of that summit as somebody with a recognised background in Indigenous rights. George has had an extraordinary career in litigation. He's represented Vivian Solon, who was deported from Australia to the Philippines, Cornelia Rao, who was detained in an Australian detention centre for 10 months, and the Sudanese Darfurian community, and many others, acting for just about every group of asylum seekers coming into Australia to ensure that they are treated fairly according to the law. He's represented the survivors and relatives of those who died in the Christmas Island boat tragedy, and represented the next of kin of one of 3 suicides in Villawood before the New South Wales coroner. He has a record of work that deals not only with asylum seekers, but with homosexuality, the general abuse of power, and he dealt with a marvellous case that would be interesting to hear a bit more about, but perhaps we haven't got time. He acted for the Emden family in their efforts to have their claim that the painting Lady with a Fan by Gerard Terbosch was stolen from their grandfather, Max Emden, by Nazi officials. And this was then recognised with George's work by the National Gallery of Victoria. So he's had a very, very wide-ranging experience in the law, and it's really a privilege to have him here today to talk about his particular experience in the litigation of the CPCF case against the Minister for Immigration and Border Protection. Please welcome him. Thank you.
Thank you, Professor. I'd like to also acknowledge the traditional owners and thank Professor Triggs for inviting me here today. I've also brought with me Emma Stevens from my office. Emma was the backbone of the case, and I've got her here for support just in case I get asked any hairy questions. I'll refer you directly to Emma. That's not true, Emma, but I want to acknowledge her hard work. I couldn't have done the case without Emma. And Emma and I are very fortunate to be backed by Shine Lawyers. They were very quick to come forward and allow us to act in this very important case. When I was a boy, I went to see this movie at the theatre, or at the cinema. It was a movie called The Voyage of the Damned, and it lasted 30 days, and you'll remember it as long as you live. And I did. It's a story about 900 Jews who left Europe on the SS St. Louis. And those refugees were transported from Europe to America. And when they were not allowed to disembark in America, they went to Cuba. And they rotted on that vessel in Cuba for some time until ultimately they took them back to Europe. And as a result, around 250 of the 900 on board are said to have perished in death camps. So it was quite interesting. I only looked this movie up for the purposes of my slides today, but I must say the subheading really did resonate with me. And if you take the voyage of our 157 Tamil asylum seekers, it lasted about 30 days too. And I'll probably remember that as long as I live too. So what was the message that came from these poor people on the SS St. Louis. After the war, after World War II, the world got together and said, this should never happen again. And they passed a series of human rights conventions and treaties, one of which was the Refugee Convention. And that convention was to ensure that this situation didn't happen again. But what the situation in Australia is that, and this is a finding of Justice Gageler, and I think he summarises the court's view quite well. Nothing in the scheme of the Act, and this is the Maritime Powers Act, which I'll tell you a little bit more about, supports an implication which would make the validity of the exercise of the powers conditional on the observance of all applicable international law norms. So the judges are saying, you don't have to worry about international law norms at all. The exercise of the maritime power is not conditioned on observance of Australia's obligations under the Refugee Convention, the Covenant on Civil and Political Rights, or the Torture Convention. Pretty clear. So let me just run you through a quick timeline on what happened before I get into the law and the decision and what might come from the decision. On about the 13th of June last year, a boat leaves India with 157 Tamil asylum seekers on board. And about 2 weeks later, they end up off Christmas Island and they're asking the Australian Maritime Safety Authority for assistance because they're taking on water and they're in trouble. And Border Protection goes to meet them. That's the Ocean Protector. They intercept the vessel and they take people on board because the boat is sinking or is certainly in trouble. The National Security Committee of the Cabinet then meets on the 1st of July, a couple of days after they're intercepted, and a decision is made by the Cabinet Committee to send the detainees to Sri Lanka. To India, but we were uncertain where they were going when we found out, but apparently they decided to send them to India. The Ocean Protector then sets sail for India for a 10-day voyage. They've been on a boat for 2 weeks, getting to Australia. Then they're taken for another 2 weeks back. Scott Morrison, during this time, refuses to be drawn on the issue, says it's an on-water operation, won't tell anyone anything about what's going on. Then we find on the 6th of July that there's a boat, the day before we find out about 157 Tamil asylum seekers, we find out that 41 Sri Lankans, allegedly Sinhalese, have been returned to Sri Lanka. Now, I've heard of a lot of things and a lot of bad things that go on in our migration policy. You've got the hellholes in the Pacific that the President has told us a little bit about, particularly in relation to children. But I've never heard of a government actually returning asylum seekers back to their persecutors, or certainly their alleged persecutors. This is the first time. I don't know if you know of any, but when I was approached by an advocate, a refugee advocate who'd actually been speaking to people on board the vessel that we ended up acting for, I was horrified because I'd seen the day before a group of Sinhalese, allegedly, or certainly Sri Lankans, returned back handed over to the Sri Lankan military and then arrested and charged on arrival. Now, you can't say it's safe to send these people back to Sri Lanka if they're actually immediately all rounded up by the police and charged on arrival. And God knows what happened to them after that. We don't know. But we were instructed and we put together an application for an urgent injunction, and Justice Crennan granted us an injunction to stop the 157 asylum seekers from being returned to the Sri Lankans. And instead of litigating the point, the government came back the next day and said to us, all right, we won't send them to Sri Lanka. We didn't know where they were sending them. We didn't know how many were on board. We didn't know anything. They were being held incommunicado. And they had been for over probably 3 weeks by that stage. Coincidentally, Scott Morrison turns up in Sri Lanka the next day, handing over boats to the Sri Lankan military so that they can intercept Sri Lankan asylum seekers instead of us having to dirty our own hands. So there he is, shaking hands with former President Rajapaksa and handing over some Australian naval vessels. While all this is going on, the clients, well, sorry, let me start again. A number of the leaders or family heads have been taken aside from the rest of the group, and they are being trained on how to drive or navigate one of these little boats. Now, they're being trained by naval officers on a boat without English language skills, and I presume none of the, from what we know, that none of the officers had Tamil skills, Tamil speaking skills. So they're being instructed on how to navigate back to India in these little boats. Also, while they're being held there, the men and women are separated into cabins like this. There's no windows in these cabins, and they're being held in those conditions for 23 hours a day. They get 2 hours outside of their cabins a day. Finally, on about the 23rd of July, this is more than a month after they set out from India, the government gives up on trying to negotiate with the Indians and brings them to the Cocos Island, from where they are transported to the Australian mainland. Now, this is the first vessel that has arrived in Australian waters and first group of asylum seekers that arrived on Australian soil since the Abbott government, and the minister goes on the rampage. It's blemished his record. They tried to keep them away as long as possible so that their unblemished record would remain unscathed. But the minister then goes on the offensive, claims that they're economic refugees. How he knows that, I don't know. There is no processing of them at sea, from what we can tell. So how he makes that statement, I don't know. And it's certainly not what we're being told. And we are in the process, while this is going on behind the scenes, trying to talk to the clients, which is very difficult because we're getting limited access, and also trying to negotiate with the Indian High Commission, because we think that it might be a good idea for our clients to speak to the Indian High Commission, because when they realise the choice is India or Nauru, never to set foot in Australia, they might want to exercise that option. But we didn't get the chance. The minister, in the middle of the night, removed our clients to Nauru on the ostensible ground that the lawyers had told the clients not to talk to the Indian High Commissioner. This is not true. Quite the opposite. We would not have told the clients to do that. We were exploring all options, and there was I'm not telling you any tales out of school, but it became public knowledge at the time that we had not told the clients not to speak to the Indian authorities. But the minister wanted to disappear them anyway. So they were disappeared to Nauru, and they remain there to this day. And soon after, the High Court set the matter down for hearing. Now, in order to understand the case, you need to know a little bit about the legislation. The Maritime Powers Act establishes a flexible regime to allow maritime officers, who are normally naval, customs or police officers or others, to prevent contraventions of Australian law. And it allows them to intercept vessels, board them, search them, detain people on vessels, to take them to another place and leave them in a safe place. And you can see from that the powers are very forceful, they're compulsive, and they adversely affect individual rights, and they restrict liberty. These, our clients were kept on a boat in detention for a month. So by the time the case got to the High Court, I'm not going to do a text-rich session, but I will just run you through these because these are critical legal questions. By the time the case got to the High Court, the essence of the case had been distilled into two questions. The first was whether holding them on the boat in prison, virtually in detention, and taking them to India was authorised by law under the Maritime Powers Act, or if the Maritime Powers Act didn't apply, whether the ancient powers of the king, which had vested in, or queen, which had vested in the executive, still applied, and whether they could order the expulsion of our clients from Australia, and whether either the Act or the executive power allowed you to do these things if the decision maker hadn't considered Australia's refoulement obligations, in other words, whether they were going to go back to a place where they could be persecuted, directly or indirectly, and whether there were even arrangements in place for them to be disembarked in India. So those were the questions. That was the first question. And then the second question was whether it was unlawful to do all that when you didn't accord any procedural fairness to the plaintiff or the other 156 people on board. Clearly you were locking them up. Clearly you were taking them to a place where they may be in danger of fear of harm or persecution. So surely, we argued, you're entitled to put your case. Well, the court found in a split decision that a maritime officer could lock you up and take you to India. 3 judges said they felt that it was unlawful to take our clients to India when there was no certainty that they could be unloaded there. So we nearly got up on that point. But pretty much all the court felt that you could do it without considering issues of refoulement. Even the 3 judges who felt it was unlawful did not find that the Australian government had to take into account its treaty obligations. And also, this was a specialised point, but simply following a chain of command. In other words, the National Security Council made the decision to take them to India, and the officers on the boat just did what they were told, and they found that that was legal in the circumstances too. So the only issue on which the judges really differed was whether you could actually set out for a 2-week jaunt and hold people for a month, trying to get them into India when there was virtually no chance of getting them unloaded in India. And in fact, they couldn't. They had to bring them back. So the court also, I'll jump to number 3. The court also found that there was no obligation to provide procedural fairness. They said that these are powers that are exercised on the high seas in kind of emergency situations. There's no time to set up a tribunal or allow people to have a voice. Although, I will talk about the nuances a bit later. And point 4 is, if it was never unlawful, no damages flow. That's a very minor point. I think point number 2 I've made up on the screen is quite interesting. This ancient power of the executive to expel aliens. It's a power that has been exercised by kings in the past. I'm not sure whether any queens have done it, but certainly it's a very ancient power. It hasn't been used in hundreds of years. 2 judges discussed this issue and they were both opposed to each other. Justice Kiefel said that that power had disappeared and it was now vested in Parliament. Only Parliament could make laws to expel individuals, not Tony Abbott and the National Security Council. However, the contrary view was expressed by Justice Keane. He felt that, it's a very important power for every sovereign nation and the executive should be able to exercise that power. What's interesting is the ghost of Ruddock and Vardalos sort of looms large over this decision, because in that case, which was a federal court case that never got to the High Court, Justice French, as he then was, he's now the Chief Judge, said that the power existed. That was how the Howard government got to deal with the Tampa boat passengers under executive power, because in those days there was no Maritime Powers Act. Now this court was very silent on that point. So 5 out of the 7 judges chose to keep their mouths shut. And it's still a very live issue. And of course, we had the embarrassing situation of putting to the court that Justice French was wrong. So that's a point a constitutional law point that's yet to be determined. So all that, as the President said, I think the decision isn't as simple as 4-3. I think there are some silver linings in the decision, and there are some nuances that are worth discussing. So you start with this negative principle as expressed so eloquently by Justice Keane. If ever I want to find a point that's against international law, I go to Justice Keane because he expresses them exceptionally well. He says Australian courts are bound to apply Australian statute law, even if that law should violate a rule of international law. International law does not form part of Australian law until it's been enacted in legislation. He's very clear, very clear. So where's the silver lining? All right. The Maritime Powers Act, that the government spent a lot of time manicuring and amending. If you recall late last year, they got Ricky Muir in the Senate, Senator Ricky Muir, to pass this legislation, this omnibus bill, which actually amended this piece of legislation as well, in the chance that we had won. But the legislation says that you've got the power to take someone and put them in a place that's safe. So what the court did was they ramped up the meaning of safe. Well, I mean, safe's a pretty clear word. They said a person cannot be safe in a place if the person is exposed there to a real risk of harm for any reason, including but not limited to a reason which would give that harm the character of persecution within the meaning of the Refugees Convention. Yes. So they're still prepared to look at the Refugees Convention, but only in the context of safety. So I think the court kind of squibbed. I think we have a very timid court. They're not prepared to impose international law unless it's enacted into Australian law. But they are prepared to say, well, you wrote this law. If it says you've got to keep people safe, it includes concepts of persecution within the meaning of the Refugee Convention. So I think that's a nuance that's quite positive. So the question you have to ask yourself is, we got an injunction to stop the government from sending these asylum seekers back to Sri Lanka. Would the government be empowered under the Maritime Powers Act to send people back to Sri Lanka? Now, it's a question of fact, but I argue that they would not be empowered to do that. It would be unlawful because the power is to take them somewhere safe. And even in this decision, the courts, a number of judges refer to Sri Lanka. Justice Crennan doesn't refer to it by name, but says the limitations in the Act make it plain that the Commonwealth is not empowered to take someone in the plaintiff's position to any place on the Earth's surface. And Justice Kiefel says the fact that the plaintiff is a Tamil would in itself be sufficient to alert maritime officers to the likelihood that that our client was a he, may claim to fear persecution in Sri Lanka. So the judges are, I think, sending a very clear warning to the government that yes, you had the power to send them to India because India was safe, relatively, but your power isn't unlimited, it is circumscribed. And I think what's much more controversial is whether the government's policy, turn-back policy of putting people in these red boats, and that's a little exaggeration, is safe. And if it's not safe, I mean, and it's patently unsafe to put men, women and children in a vessel navigated by someone who's untrained and told, just drive that way and you'll get to Indonesia or India, as the case may be. So I think that this case does open up a challenge to the turn-back policy. I've got a couple of quotes, but I've essentially summarised them. But really, the top point is that sending someone somewhere that's safe for the person to be in that place is evaluative. It involves a risk assessment on the part of the maritime officer or those directing them. And I think you could easily make a case to the court that putting someone in a red boat, a child in a red boat navigated by someone who has no navigational training, doesn't know what they're doing, is not safe. So that's another silver lining, perhaps. The ability, the court said that there was no procedural fairness to be allowed on board the vessel under the Maritime Powers Act, but they did say in order to determine whether a place is safe, you have to know something about the person. You have to know something. You know, if they're an Iraqi or an Iranian, you might not be able to send them back to Iran. If they're Sri Lankan, you might not be able to send them to Sri Lanka. You need to, in order to do the evaluation of the risk, you need to know something about them. So the court was not prepared to give you, the individual who is detained, a full right of procedural fairness, but they said you cannot make a decision about someone's safety without knowing something about them. And Justice Gagler summarises it, I think, well, summarises the discussion. He says, to be able to be satisfied that a place is safe, an officer might need to consider the individual circumstances of the person, but that will not necessarily be so in every case. The opinion or assurance, that worries me, the assurance of other persons with apparent knowledge and authority might be sufficient. So, you know, the officer might say, well, Tony Abbott told me, therefore he's in authority, he's got apparent knowledge, and therefore that might be sufficient. But it's arguable. The other point, which is the same point that the President raised earlier in S4, is once again they raised this point about the term of detention and the purpose of it and how long you can keep people in detention. So it's a theme that keeps coming back. And it's not patently obvious from the decision. But here is Justice Gagler. He says, a Commonwealth statute which authorises executive detention must limit the duration to what is reasonably capable of being seen to be necessary to effectuate an identified statutory purpose, which is reasonably capable of being achieved. It's the same theme as S4. And I think the court is heading at some stage for a clash with the government, hopefully, over indefinite detention. You can see it in S4, you can see it, that they keep saying it again and again. Now, of course, this was a 4-week detention and it was found to be reasonable in the circumstances. So even with these comments, the court are prepared to allow detention, although 3 judges felt that this detention wasn't lawful. 3 judges out of 7 said that it wasn't lawful to take them to India and detain them and lock them up during that time. So we're getting close. And even the Chief Justice says, and this is based on the same principle, a decision to take a person to another country would not be valid, not be lawful, if it were known when the decision was made that the country was not one at which the person could be discharged and that there was no reasonable prospect of that would change. So arguably, Iran does not accept people back, asylum seekers back into its borders. It would be a pointless voyage to take people via the Caspian Sea and try and leave them in Iran. And I would argue, Justice French's position, that that would be an invalid exercise of power. The government may still argue, well, we're allowed to negotiate, let us try and negotiate, and 3 judges didn't accept that in this case. It would be a question of fact whether they would accept it in any other case. And that's really it as far as my review of the case goes, but I'm very happy to answer questions.
My question is of basic human rights. If we consider all the European dominated governments outside Europe as aggressors, all of you and all of your law are invalid, not applicable.
Well, that's one view, but I don't think the High Court would agree with you.
Who cares about High Court? High Court itself is invalid. All European outside Europe are aggressors.
No, I don't disagree with you, but I'm a lawyer, I sort of buy into the system. So there is a case, by the way, just for your information. A group of Aboriginal people did run a similar argument that the white man's law didn't apply. But, and it was, I think, in the 80s, and the court wasn't very receptive to it. Is that the only question? It's either a very boring case or I explained it very well.
I have a question about the amendments that were made through that Legacy Case Select Act at the end of last year and
Yes.
what I suppose they mean now for the future of a case like this. So I'm thinking specifically of the amendments which allow people to be returned even if it is in violation of our non-refoulement obligations and how that might affect people in this kind of situation.
Thank you. That's a good question. And you've reminded me of a point that I forgot to make earlier, so thank you. I think that the Act actually helps my argument. I'll come back to the negatives in a minute about that sort of boat being unlawful, because the Act actually changed the definition of a place to extend to a vessel. So putting a person in a place which includes a vessel has to be safe. You have to make an assessment about whether it's safe. So they kind of shot themselves a bit more in the foot with that. And look, I don't think that taking our international obligations out of the Act would make any difference, because if you looked at what the court was saying, they didn't consider them either. It really comes down to safety. So until the government removes, you can send them anywhere in the world, even a place that's not safe, I think you've got those arguments. And I think that this case might have been decided differently if they had tried to send the asylum seekers back to Sri Lanka. And the government was arguing that before the High Court. And I found it quite interesting. High Court judges they're not normally expansive. They try and limit their decisions to the points in question. But a number of them did say that Sri Lanka might not. India was safe in the circumstances. Well, certainly there wasn't enough evidence to show that it wasn't safe, but Sri Lanka might be different. So they actually expressed that concern in a number of judgments. And I think that there is a shot across the bow, excuse the maritime pun, but there is a shot across the bow of the government that, look, you can do things to people, but because of this legislation, you can't put them in an unsafe place.
Thank you, Mr. Newhouse. I'm not a lawyer, so I just don't understand how our government can actually, at the moment, if someone's trying to seek asylum, turn the boats back and not take responsibility with regards to looking after those people. And also, does it also mean, talking about the Tampa case,
yeah.
Can a government of the day just change the Act to suit their needs or what they're trying to achieve?
The answer to your question is sadly that in Australia we have no Bill of Rights, we have no constitutional protections for human rights, maybe a couple like freedom of religion, but we really don't have human rights in our constitution, and therefore the government legislation is all powerful, and that's what the judges are saying in this case. That's the very sad thing about this case. I've tried to make the best of it today and show you the silver lining, but it is mildly depressing that our High Court says that the law of the land is the law of the land. And we actually have a racist constitution. If our government wanted to make a law that said people of a certain colour aren't allowed to work in this country, it would be legal under our constitution. And the reason for that, I'm diverting from the original topic, but the reason for that is because when our federation, when the states federated, all these sorts of rights that a person is created equal, everyone has equal rights, existed in the US Constitution. But the Australians had seen that in operation. And at the time, the West Australian government was trying to exclude Asian people, or Chinese people in particular, from the goldfields. They wanted the power to not issue mining licenses to Asian people. And so that carried into our constitution in the race power. They've got the power to do anything. Not only do they not have to abide by international norms, unless it's incorporated into our legislation, they can actually make laws that are racist. So, sorry about that.
Thank you very much for that description. It does help to simplify and to explain some of the nuances and some of the judgments. But what it seems to me you're basically describing is that the majority of the court felt that they were constrained by the precise language of the Maritime Powers Act. And they concentrated all their efforts to be humane, if you like, on the right to transfer to a safe place.
Correct.
So they focused on this very, very simple idea that was still there to protect basic human interests. I guess my question is, why do you think the High Court is so reluctant to say Parliament is not above the core principles of the common law? That there are principles of legality, which our Chief Justice has been in part responsible for developing. Why have they not really grasped that nettle and said that there are core common law principles of legality, detention of people, that would at least moderate, as a matter of statutory interpretation, what the phrase "a safe place" might be?
Well, I think the court said that international norms are not part of the common law. If they were, they would have imposed them on the government. So that's the first point you raise. Why isn't that? Why wouldn't they impose the common law? Well, they do impose the common law, but they couldn't find anything in the common law to hold the government accountable. Nor could they hold anything. Nor could they. Well, 3 judges did. Nor could 4 judges find anything in our administrative law that would hold the government accountable, and nor could they find anything in the statute law that would hold our government accountable, apart from the word "safe." So I think your observation is right, and I do believe that the High Court was trying to be humane. Well, when you ask me why they behave in that way, I can't put myself in their heads, but it's a political process. And you can see, President, what happens when you stick your neck out with a government that doesn't like what you've got to say. So I think that, I'm not suggesting that the High Court are timid in any way, but it's a dangerous political process that they're navigating, and they are trying to, make decisions as best they can. I'm not going to speak for them. I think that there are international norms that could have been incorporated into Australian common law. There are courts that have been prepared to go that far. But I think in this country, we have a High Court that really sees their role as holding the government accountable, but only within very limited constraints. In Europe, countries sign up to the Convention on Human Rights, and even English law has developed more than Australian law. We came from the same source, but English law is much more advanced in terms of human rights law, because they actually have human rights now. We don't. And I don't think it will change until Australians demand human rights. But the problem that we have in this country is that it's not in the majority's self-interest to, give away rights and grant rights to minorities. And until people are prepared to fight for those sorts of rights and demand them in our Constitution, or even in a Bill of Rights, I don't see it happening. And in fact, what we've seen is an erosion of rights. You saw my image of when I was a boy, what happened after the war, and that's scarred etched in my memory. But that's far away now for a lot of people, and a lot of young people don't. It doesn't resonate, and it doesn't mean anything. And it doesn't mean much to our leaders. After the war, nations got together of all types, communists, non-communist, everyone got together and said, these are basic human rights. And here are we in 2015 with legislation that says we specifically remove those rights. You are not entitled to those rights. What's happened to us? What's happened to our humanity? Now I'm lecturing. Did that answer your question?
Thank you for your talk. I was wondering if you could expand on what the definition of safety is. It might be a bit of a cheeky question, but I was wondering, with the Amnesty International report and now the Australian Human Rights Commission report, could Nauru be considered unsafe for some people?
Okay. This was a special case. And one of the things about that is, I'm just thinking of your time, is that you don't get to argue the facts like in a normal court. Everyone agrees facts and then it goes up. The only way we got this on so quickly was to agree facts with the government. And so because we were arguing with them about whether India was really safe, we felt it wasn't, but the government lawyers were not prepared to let us go to the High Court on a special case unless we sort of fudged that issue. And if you actually read the decision, Justice Hayne and Bell, they wrote a joint judgment. They're a bit critical of us, both us and the government, because they said that that issue should have been resolved. And they saw through what had happened. But to do that, we would have had to go on to a court and really argued the facts over whether India is safe or not. We would have been stuck in court for years. So the issue of what was safe or not was really determined on the basis of the stated facts, and there wasn't much there about whether India was safe. We made representations during the hearings, and the Commonwealth said you can't do that because it's not an agreed fact. And we got the message through to the judges, but some of them used that to a little bit slip out of the argument, because they said there's not enough facts in here to show that India was unsafe. But then there weren't enough facts to show it was safe either. But we didn't meet the threshold of finding it was safe. But the words are fairly clear. The content of the term safe for the person to be in that place is evaluative. You've got to evaluate it and involves a risk assessment. Now, I don't know. It really will depend on what those 7 judges say. But, I reckon if I explain to them, look, this is what they do. They try and teach Tamils in English how to navigate, and then they put 50 or 20, I don't know how many people, in the hull of this little boat, and they point them in that direction. They go that way. What do you reckon? I don't know. So the court didn't give us that much help, but that's useful because we can always argue the point later on if it happens again.
Helpful instruction on this. I learned a lot. I'm just wondering, what would you be thinking about next steps? Where would you be taking this?
I think the next step is, well, these two images, if they ever try taking asylum seekers back to their persecutors, I'll run that case. And we won the injunction. So the court was, Justice Crennan said, whoa. She didn't say whoa, but she did give us an injunction. So I think that there's enough there. And also, I'm waiting for one of these. It's very hard to run one of these cases because there's only a matter of hours between people being intercepted, turned around, put on a boat and driven back. But this is going on all the time out of Indonesia, although I don't know how much it's going on lately. But I think that's the next step. Now, it'd be very interesting to see whether the government try and amend the Act, because they went through, if you recall, they went through blood. They spilled blood trying to get that amendment. But the High Court latched onto the one thing, as the President says, that really did protect people. The only thing that the government could do now is try and get an amendment through, and I'd love to see them convince the Senate that we need to be able to send people to unsafe places. It'll be interesting to see what happens. So I think that those are the next steps. I also think the next step is also this, S4, and the people that are rotting in immigration detention indefinitely because they're ASIO affected, because they're Iranians and they can't be returned, stateless people. I do think at some point this court's going to address it and possibly overturn the Al-Khatib decision. That's probably the next step. But that's really the only protection that we have in our Constitution. And that's the Magna Carta point and the S4 point. So I think when I talk about there is silver lining, those are the silver lining points. The indefinite detention, there might be some hope for people, unsafe practices, and sending people back to their persecutors.
Is there an identified statutory purpose in putting people on manus and keeping them there forever?
Say that again.
Is there
An identified statutory purpose for which point?
for putting people on a manus, keeping them there?
Well, that's a different question. I'll answer it in two ways. First of all, I'll pose a different question, whether it's legal to keep people indefinite. What's the statutory purpose for keeping them in immigration detention? Here. And then I'll deal with manus separately. Keeping them here, ostensibly, one of the points is to process them. That's a legitimate statutory purpose. You can hold them while you're processing, or you can hold them to deport them. And I think the government's also saying they're holding some on national security grounds. I'm not quite sure about that. But so those are legitimate purposes. But how long can you try and deport someone when they're, at a certain point, I think Gagel is really clear on this, it has to be an identified statutory purpose which is reasonably capable of being achieved. So at some point you've got to give up. Also stateless people, if you take Al-Kateb's case, Al-Kateb was a stateless Palestinian. Israel, he was born in Kuwait, I think, and Israel doesn't accept back Palestinians born outside. I don't think they accept anyone back, but they certainly didn't accept Mr. Al-Kateb back, so he had nowhere to go. So how could the government have been holding him for a statutory purpose that was capable of being achieved? Israel was never going to give him back, let him back in. Ultimately, he was released and he's now an Australian citizen. He's a lovely man, Mr. Al-Kateb. But because the government realised that they were going to have to hold him forever. So I do think S4, Al-Kateb, I think CPCF and S4 may lead someday to a challenge to indefinite detention. Manus is a different story. Manus, you're being held under Nauruan law, not Australian law. So those principles don't apply in Nauru. However, as Emma will tell you here, Emma is one of the few lawyers in this country who have fought a constitutional case on Nauru. There is a real constitution. This is the kind of sort of depressing thing about being a social justice lawyer. We went to Nauru, where they actually do have a constitution that has real rights. It says that I don't know who put it together, someone, I think some hippie in the 70s when there were real rights. But you wouldn't get anyone doing it now. But there are real rights, and in the New Guinea constitution too. And Emma went over there to fight it and say, look, these people aren't, there are rights in the constitution to a lawyer, there are rights to a fair trial, there are limits on how you can hold people. You have to be held pending deportation, isn't that right, Em? Yep. And Justice von Duser, a former president of this this august body, found that, oh well, you might have a case, but we haven't reached that point yet. It might be that if their detention was indefinite, that it would be unlawful under the Nauruan constitution, and he left that open. But how long had they been there when you went there? 8 months. 8 months wasn't enough for Justice von Duser to say that they weren't being held with a proper purpose. And very well done, Emma, going to Nauru. I would never do that. Or Manus. Thank you anyway. If there's no more questions, I'm out. Thank you.
Well, if there's not another burning question, thank you very much, George. Thank you. I really think that although these are just silver linings and little incremental moves forward, I think we are slowly reaching a position in which the High Court will at some stage say that's enough. You can't do this anymore. But it's a profound question that doesn't only affect asylum seeker refugees. It affects the mentally ill, those that are unfit to plead, all of those, and there are surprisingly large numbers of them, all of those who are in one form or another of executive detention at the discretion of the executive. And I think it's a very important work that Emma and George have been doing. Now, we're very dubious of bottles of wine and Mont Blanc pens, but we do have a very small gift to thank George very much for his work with us. Thank you, Ben. Thank you all for coming today.